The officer walks up, gets the license and registration, then comes back to the driver's window a second time and says it. "Sir, step out of the vehicle." The driver doesn't move. You can hear the tension spike in his voice. The officer's tone shifts. "Step out of the car, or I will drag you out." 4 seconds later, the door is open, the driver is on the pavement, and he's in handcuffs, charged with obstruction on top of the equipment violation that started the whole thing. If you believe you have an absolute right to stay inside your car, when an officer tells you to get out during a traffic stop, you are holding a belief that can get you physically removed from your vehicle, arrested, and booked, all while the law is standing firmly on the officer's side. And I'm not saying that to scare you for the sake of it. I'm saying it because I've sat with too many clients who thought they knew the Constitution better than they did, and their refusal to open the door became the worst decision of their night. By the time we finish this video, you'll know exactly why the command step out is legally bulletproof. In almost every traffic stop, what the Supreme Court has said about it, and the exact words you can say in that moment to protect your rights without putting your body on the line. Let's start with what most people think the law is, because the myth is everywhere. You'll hear it in YouTube comments, at backyard barbecues, from your cousin who watched 3 law school TikToks. Once you've handed over your paperwork, the officer needs a new reason tad. That's a reasonable suspicion of a crime separate from the stop itself, its sham, before he can order you out of the car. People wrap this belief in the Fourth Amendment like a force field and assume that rolling up the window on an exit order is a righteous stand. That belief is wrong. Not kind of wrong. Completely upside down wrong. And the case that proves it has been settled law for nearly half a century. In 1977, the United States Supreme Court decided Pennsylvania versus Mims. Harry Mims was pulled over for an expired license plate. The officer asked him to step out of the car, noticed a bulge under his jacket, frisked him, found a loaded revolver, and arrested him. Mims argued that the officer had no justification to order him out of the car, and therefore everything that followed, the frisk, the gun, the arrest, should be suppressed as the fruit of an unconstitutional seizure. The Supreme Court unanimously disagreed. The court held that once a motor vehicle has been lawfully stopped for a traffic violation, the officer may, as a matter of course, order the driver out of the vehicle pending completion of the stop. The officer does not need any additional suspicion, not a whiff of danger, not a nervous glance. The justification isn't about you at all, a tan. It's about officer safety. The court pointed to the inordinate risk an officer faces when approaching a person seated inside a vehicle, where a driver's movements are partially concealed, where a weapon can be reached in a fraction of a second, and where a simple traffic stop is statistically one of the most dangerous moments in policing. The intrusion of being asked to stand on the side of the road for a few minutes, in the court's words, de minimis, hakeb, a trivial, almost negligible additional intrusion on your liberty when weighed against the government's interest in making sure that officer goes home that night. And if you're a passenger, don't think you're off the hook. 20 years after Mims, the court took up Maryland versus Wilson. An officer stopped a speeding car, noticed the passenger acting nervously and sweating, ordered the passenger out of the vehicle, and recovered cocaine that fell to the ground as the passenger exited. The passenger argued that Mims applied only to drivers because the driver is the person being investigated. The Supreme Court saw it differently. It extended the Mims rule to all passengers, holding that the same inherent danger exists regardless of who is behind the wheel to haul. A passenger can pose just as deadly a threat, and the officer can order any occupant out of the car as a matter of right during a lawful traffic stop. No individualized suspicion required. Just the stop itself, plus the order to exit. So when an officer looks at you through that driver's window and says, "Step out of the vehicle," he is standing on legal concrete that was poured by the highest court in the land. If you refuse, you are not asserting a constitutional right. You are disobeying a lawful order. And once that happens, the legal floor starts to shift under your feet in ways most people don't see coming. Let's walk through the incident I described at the beginning. Chasse, the one caught on body cam a chasse, because it's a nearly perfect composite of exactly how these refusals snowball into real criminal liability. The driver in that footage did something I see all the time. He tried to litigate on the side of the road. Why? I haven't done anything. I'm not getting out. In his head, he was asking a reasonable question. To the officer, that wasn't a question. It was a refusal. The officer repeated the command, this time with an explicit consequence. Or I will drag you out. Still, the driver didn't move. At that moment, the officer had more than enough legal footing to open the door and physically remove him. And the charge that followed, TOUND, obstruction of an officer chand, didn't require the driver to swing a fist or threaten anyone. In most jurisdictions, obstructing or resisting a peace officer includes willfully refusing to comply with a lawful order. The order to exit the vehicle is lawful under MIMS. The refusal to comply is willful. That's a separate criminal charge, often a misdemeanor, but one that can stick and sit on your record long after the cracked taillight is fixed. Now, does the officer have to warn you? The short answer is no, but in practice, many officers do, because it looks better on camera and gives the driver one last chance to de-escalate. Step out or I'll remove you is not a threat of illegal force. It's a final, legally permissible directive. The law allows an officer to use reasonable physical force to effectuate a lawful order, so long as that force isn't excessive under the circumstances. The Fourth Amendment's objective reasonableness standard, set out in Graham versus Connor, applies here. The officer can use the amount of force a reasonable officer on the scene would use to gain compliance, given the totality of the circumstances current, the severity of the refusal, whether the driver is actively resisting, and whether there's any immediate safety threat. Pulling a driver out of a seat after multiple ignored commands, using a controlled arm escort or a compliance hold, is going to be viewed as reasonable by almost any court, especially if the refusal is prolonging an already lawful detention and creating an unpredictable situation on the side of a roadway. This is the point where I tell you what I tell every client who asks, what could I have done differently? Because you can't undo the stop, but you can avoid turning a 5-minute ticket into a ride in the back of a patrol car. When the officer says, "Step out of the vehicle," I want you to have an exact phrase ready, not something you debate. Something you can say calmly while your hands are visible and your body is moving. Here's the phrase I recommend in this precise scenario, and I'm going to explain exactly why every word matters. Officer, I'll step out as you've ordered, but I do not consent to any search of my person or my vehicle. Say it out loud once, just so your mouth knows the shape of it. That sentence accomplishes 3 things simultaneously. First, it communicates compliance. The moment you say, "I'll step out," you've broken the refusal that was about to trigger an obstruction charge. You are following the lawful order. That alone protects you from the arrest we just talked about. Second, it explicitly and unambiguously withholds consent to a search. Under the Fourth Amendment, a consensual search is a major exception to the warrant requirement. If an officer asks, "You mind if I pat you down?" and you stay silent or shrug, a court might later find that you impliedly consented. Saying those words out loud, "Town, I do not consent to any search, pal," creates a clear, recorded assertion of your right to be free from a warrantless search that isn't supported by another exception, like probable cause or a lawful pat-down, under Terry versus Ohio. And third, it does all of this without sounding combative. You aren't saying, "I know my rights," in a confrontational tone, which some officers interpret as a challenge. You are stating your position factually while physically complying. That combination is your best shield. Now, I can hear the next question forming in your head, because it's the right one. What if the officer says he's going to search you anyway? Then you've done everything you can. You've complied with the exit order. You've clearly revoked any claim of consent. If the officer proceeds to pat you down without your consent, the legality of that frisk will depend on whether, at that moment, the officer has reasonable suspicion that you are armed and dangerous under Terry. And that's a fight that happens later, in a courtroom, with a lawyer like me standing next to you. But you don't win that fight by refusing to get out of the car. You win it by getting out. Keeping your mouth in a posture of calm compliance and letting the officer articulate TAND, or fail to articulate TAN, a basis for the frisk on the record. Every time you force an officer to put hands on you because you refused a simple exit order, you hand the government a pile of additional justifications. Resisting, officer safety concerns, heightened tension. You make your own legal defense harder. There's one nuance I want to flag because it's where some good lawyers will disagree, and it matters if you're ever trying to apply MIMS in a stop that feels borderline. The key phrase in every case is lawfully stopped. Mims and Wilson both assume that the initial traffic stop itself is constitutionally valid. If an officer pulls you over without reasonable suspicion of a traffic violation, or without probable cause of a crime, the stop is unlawful from the jump, and any order that flows from it, including an order to exit the vehicle, is fruit of the poisonous tree. That's a bedrock Fourth Amendment principle from Corbin versus United States. So if you're stopped for a reason that you genuinely believe is fabricated batant, and you need to be very sure, because I didn't think I was speeding, is not the same thing kind. Your recourse is not to argue at the window, it's to make a record, comply minimally with lawful orders, and challenge the stop later with counsel. But here's the critical practical point. During a stop that appears lawful on its face, Paul, an officer says your taillight is out, your registration is expired, you rolled through a stop sign ASIN, the MIMS rule applies. Disobeying the exit order in that moment is almost certainly going to make your situation worse, not better. You might be wondering about what happens when the officer's command goes beyond just stepping out. Can an officer order you to leave your keys in the ignition, or sit on a curb, or keep your hands on the hood? The Supreme Court hasn't drawn precise boundaries around every conceivable post-exit command. But the framework from MIMS tells us that additional orders tied to officer safety during the stop are generally going to be upheld as reasonable de minimis intrusions. Telling you to keep your hands visible or to stand in a specific safe location away from traffic is going to be lawful. If the order starts to feel like a custodial arrest of fine, for example, handcuffing you without probable cause just because you're being detained, that's a different legal question under the Fourth Amendment, and one we'll break down in another video. For now, just internalize the main rule. During a lawful traffic stop, an officer can order the driver and all passengers out of the vehicle, and your refusal to comply is a separate offense that opens the door to physical removal and additional charges. I want to leave you with one more legal thread to tug on, because if you've been paying close attention, you might have noticed that the cases I cited, Mims and Wilson cited, are primarily about officer safety, not about investigative tactics. That distinction matters. When an officer orders you out of the car merely to gain a tactical advantage, say, to separate you from a passenger so they can ask questions and compare stories, the courts have still upheld the order under MIMS because the officer safety rationale operates as a bright-line rule. In other words, the officer's subjective motive for giving the order is largely irrelevant as long as the stop is lawful and the order to exit is given. The Supreme Court made that clear in Warren versus United States, where it held that the subjective intentions of an officer play no role in ordinary Fourth Amendment analysis. So even if the officer's real reason for getting you out of the car is to put you off balance, see your body language, or get a better look inside the vehicle, the exit order remains lawful. That might not feel fair, but it's the legal reality you're dealing with the moment those blue lights flash in your rearview mirror. So let's come back to the body cam footage one more time. The driver is on the ground, breathing hard, hands cuffed behind his back. The officer is kneeling next to him, saying something about how this could have been easy. And as I watch that clip, I don't see a guy who was making a bold constitutional stand. I see someone who was given a lawful command and met it with a refusal he believed was righteous, only to learn that the law had already settled the question against him 20 years before he was born. You now know better. You know that the command step out of the car is one of the most legally fortified orders an officer can give during a traffic stop. You know that refusal is not protest, it's obstruction. And you have a phrase ready to cha. Officer, I'll step out as you've ordered, but I do not consent to any search cam. That splits the difference between protecting your rights and protecting your physical safety. That's not surrender. That's strategy. Of course, what happens if the officer then asks to search your car even after you've clearly said those words? That's a whole different arena, and it's one where a single sentence from you can either slam the door shut or blow it wide open. Next time, we'll walk through exactly how that encounter plays out on camera and the legal tripwire most people trip over without ever realizing it.